If this keeps up, you will die in a jumpsuit in prison.
This sentencing hearing involves a defendant with a very long history behind him. The defense asks the court to consider his age, his health, and the events that shaped his life, but Judge Aquilina is also looking at the seriousness of what brought him back to court. Watch how the judge responds when the defendant tries to explain his role in it all. My name is Dan. This is the Courtroom Files.
All right, this is docket 25369FH, 23967FH, 23969FH. And 256131FH. People of the state of Michigan versus James Clark. Legion? Yes. Okay, counsel, your appearance for the record.
Thank you, Your Honor. Randall Berman on behalf of the people.
Thank you, Your Honor. Michael Anderson on behalf of Mr. Legans, who does appear personally to my right.
And which files are you on?
I am on the first two, Your Honor. So 23, 6.
967.
Yeah.
And 23969.
Yes.
And then Attorney Goodrich is here. Are you here on the other two?
Yes, Your Honor.
All right, thank you. Appreciate that. Okay. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Put your hand down. You taking any medication yesterday or today?
Yeah.
Is there medication you're supposed to be on that you're not on?
Yes.
And not being on that medication, does that interfere with your ability to understand your attorneys or this court?
No.
And are you feeling okay today, sir?
Yes, I am.
All right. And any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to talk to both of your attorneys in regard to sentencing?
Yes, I have.
Have you reviewed the pre-sentence investigation report with them?
Yes, I have.
All right, thank you. And counsel, you believe he's oriented to date, time, and place, and does understand what's occurring despite having taken his regular medicine along with not having some of it. Is that correct?
I do, Your Honor, based on numerous conversations.
Yes, Your Honor.
All right, thank you very much. On behalf of the people, are there any corrections, additions, deletions?
Yes, Your Honor. Obviously, as it pertains to the 967 file that we're here for sentencing on, the attorney is Mike Anderson, not Luke Goodrich. And he is appointed. I'm sorry, he's retained, not appointed.
Thank you.
Those are all the factual corrections that I've had.
So I'm changing that on the basic information sheet. I'm changing the cover page. And let me see if it's under evaluation plan. Yes. To the first line. So then, Mr. Goodrich, are you here on the files that will be dismissed?
That is correct, Your Honor. Mr. Anderson will be making all arguments on behalf of Mr. Legans today.
All right, Joe, is there any, I don't want to waste your time. You're certainly welcome to stand where you are, but is there any reason beyond this that you need to be here?
I don't believe so, Your Honor, but
Yeah, I appreciate you being here. Any objection to Mr. Goodrich carrying on with the rest of his cases?
Then I might.
No, Your Honor.
All right, thank you very much
Thank
for
you,
your
Anna.
service, sir. All right. Sir, and counsel, did you have any additional?
I do, Your Honor.
Okay.
Just in information report under highest grade completed, it says unknown. That is 7th grade. And then under religion, it says unknown, that would be Baptist.
Where are you? And what page is that on?
Your Honor, right below highest grade completed on the basic information report.
Always. Okay. Or what is it? Back to you.
Best. On page 2 of the basic information report under jail credit, it says 247. Based on the calculation that's later in the report, they have the end date of credit being May 19th instead of May 20th. So I believe it should be 248 instead of 247.
Correct, Your Honor.
Okay, and then change of the basic information sheet, cover page. Okay, and I also changed it under account line.
Thank you, Your Honor. And then on page 15 of the pre-sentence investigation, under marriage,
Yes, sir.
it has his son as deceased. That is incorrect. He's live and well and 27 years old.
Good to hear that. Okay, and then again, under education, oh, he does say something great. Okay,
Yes.
great.
And then under employment, on the exquisite soul food, it notes him as a cook. He was also a co-owner of that establishment.
Okay, and then he's been unemployed since 2018.
Yes, that's correct.
Sir, if you don't feel well, you can certainly sit down. I don't have any problem with sitting down.
I'm all right.
All right, is the chair still there?
I took it away, but I can bring it back.
Do you want it?
And fall out.
Yeah, we don't want you to fall down, sir. Thank you. There.
That is all I had in terms of the basic information. Your Honor.
All right,
Judge, I had one other factual correction. if I may.
Yes.
I'm sorry. On the cover page under plea agreement, I just noticed this. It says amended plea, the defendant pled guilty to count 1.
yes,
I think we best note that the defendant pled guilty to original count 3,
okay,
subsequently count 1 entered. I think it's the best way, as I have it forth. And I will explain that in a moment.
okay.
And Your Honor, I have no objection to that change.
Okay. Okay. Sir, you pled guilty to what ultimately was count 1, controlled substance, delivery, manufacture of controlled substance less than 50 grams with habitual force that is punishable back to life. Do you recall that?
For the second,
Okay, thank you very much. And do we have any issues with the guidelines?
Yes, Your Honor. Mr. Henderson correctly indicates that OD 19 should be scored at 0, not 10 points.
OB 19 is 0.
Correct. That makes the total OD's point value 15
Change has been made.
and a level 2.
Change has been made on change in the basic information sheet. Council, are there any additional corrections?
The guideline range then goes to 10 to 46. Your Honor.
10 to 46, and we have defendant, any additional corrections?
No, Your Honor.
We just changed the basic information sheet.
Also on page 2, the recommendations.
Okay.
The guideline there as well.
I'm also changing under that recommendation narrative, it says the 247, changing it to the 248 days. All right, then I think everything looks like it's consistent.
I'm sorry,
Is
Your
there
Honor.
something else?
I just caught this under page 1 of the pre-sentence investigation.
Yes.
And Mr. Berman can certainly double check on this. But my guess is where it says docket 23-00369 FH. Given that the offense date is July 18th of 2024, I believe it's docket 24-00369 FH.
I'm sorry, I'm not seeing what are you looking at the cover page or?
It is under additional information. Your Honor, can I briefly approach?
Yes.
Great.
There's so many pages to this.
Yeah.
I want to make sure you have the right one. Oh, under additional information, okay?
And then docket,
Oh,
it says 23. I believe it should be 24.
I believe it is.
is it 23369 FH or a different one?
That's not what I have. Twenty-five, 369 FH.
So it's the 23 should be changed to a 25. Is that what you're saying? Yes.
Yes.
That's, okay, got that, okay. All right, and then can somebody, before we,
I'm sorry, where are you looking? Because where I'm looking says 25, 369 FH.
go to show them where, it's under additional, so we don't usually make, it's under additional information on page 1. It's the second paragraph from the bottom.
Thank you.
Yeah, that was a good catch. All right. I also see on the cover page that he has 2 civil infractions there's a no pickup because there's civil probably in the range is too far away. There's 2 active warrants. Those been taken care of?
No, Your Honor, I became aware of them when I received this. I did double check the register of actions. They're traffic infractions.
Right, I figured
On fine.
23, so he probably just owes a fine plus late costs and all that.
Yes,
Okay. All right. On behalf of the people, what would you like me to know?
Thank you, Your Honor. Originally, we were before the court, just by way of catching up on April 2nd of 2025. At that time, on this file, we entered into a plea agreement where the defendant pled to it on an amended information count 3 as an habitual offender 4th. I did that under a 1-year delay pursuant to MCL 771.1. And if the defendant remained bond compliant, and had no new charges, the defendant would be sentenced on count 3 as I have 4 with no further upfront jail. I would dismiss all those other files and the remaining files or charges on this file. And then I said if the defendant, or the agreement was if the defendant is non-bond compliant or is charged with new crimes, count 1 shall enter as I have 4 with no sentence agreement, and count 3 that was added pursuant to that plea agreement would be dismissed. I did that because of the advocacy of Mr. Anderson. He actually got me feeling bad for Mr. Leggins, and I was provided with some health information for him and said, yeah, this is someone we ought to try to do something here. So let's do this. Let's reduce this. Let's not put him in our jail, and let's let him just for 1 year. That's all it's going to take is 1 year. Let him prove to us that he can get a job or volunteer his time or just sit in the house and watch TV. But for heaven's sake, let's stop with the drug dealing and having guns. And we didn't make it very long. At that point, we then had bond violations because he picked up the new file, that being the 256131 file while he was on the 1-year delay, where there was a raid at where he was at, and he was sitting on a bed with a bag of dope on the bed and other items in the room that oddly enough also contained the medical information that had previously been provided by counsel to get me to give him a deal. I then, instead of having him getting sentenced pursuant to the guidelines on this case with no agreement, still somewhat feeling for Mr. Leggins, we entered into this agreement where I'm going to say that he only does the 24 months. I've practiced in front of your honor enough to know that this court does not take kindly to drug dealers. This court does not take kindly to people not following the court's orders, and that the situation for Mr. Leggins possibly could be a lot worse. I note in that new file that he got charged with law and bond. His guidelines, if I remember correctly, start, I think it's 70-something months. Today I was provided by counsel a packet from CMH with a treatment plan for Mr. Leggins. It appears as though he was ordered no bond by this court in September of 25. And then in December of 25, CMH came out and gave this treatment plan. And I think the prospect here is that even though there's an agreement that there's a fixed minimum of 24 months, Mr. Leggins would like to ask this court for some kind of treatment. Well, it's my position you can get that in person, Your Honor. At this point in time, I have nollies for the dismissed files. 23969 FH. I am going to be dismissing another high severity felony delivery of less than 50 grams, along with possession by a felon of a firearm, possession of ammunition by a felon, and a felony firearm charge. And then in 25369, I'll be dismissing firearms, possession by a prohibited person, controlled substances, maintaining a drug house as an habitual offender fourth. And then finally, in the 25131 FH file, I will be dismissing the controlled substance delivery manufacture of methamphetamine, the controlled substance delivery manufacture of less than 50 grams, the weapons ammunition possession by a prohibited person, the weapons dangerous weapon possession miscellaneous, and the habitual offender fourth notice. The defendant has 9 prior felonies on his record. To think that he wasn't afforded some form of treatment or help at some point in time would be naive of us. So I'm asking the court to follow the agreement. The defendant has earned his 24 months fixed. He's earned quite a bit more, but that's where we're at. He has almost a year, getting close to a year of credit. And then he can do his time on parole and have a nice tell if he decides to continue with this. I don't see the problem here as Mr. Leggins being just a user and having a substance abuse problem. He's always caught with large quantities. There's always seems to be guns and ammunition nearby. Tells me he's a drug dealer. Tells me he's peddling drugs to the community. He's not working. He's not paying his taxes like the rest of us. And at this point in time, I think the message that needs to be sent is that he needs to go to MDOC. I'm sorry he has health issues. I'm sorry he appears in court today and has to sit down. I would suspect that the Michigan Department of Corrections has a much better system and is better equipped to treat and help Mr. Leggins with whatever issues he has. I'm asking the court, while it is a sympathetic situation.
While it is a what situation?
I'm sorry. It is a sympathetic situation,
Thank you.
and he is 67 years old. He has earned this, and I'm asking the court to follow our agreement. Thank you.
So the question I have is, the agreement was for a fixed 24 months. Were any of these violations after that agreement? Did he violate this agreement?
No,
No,
this is
you're-
the new agreement we have with the fixed 24 is since he's been in jail. So
Okay.
no, he has not.
That's correct, Your Honor. There haven't been any bond violations as he's been in custody. Your Honor, I know that you reviewed this pre-sentence report, and one of the things that you looked at is probably the lengthy criminal history of Mr. Leggins that spans multiple pages. I do want to draw your attention to that criminal history. And what you'll notice, Your Honor, is yes, it starts in 1983, starting with a larceny over 100 in 1985, 1988, 1991, where there's a controlled substance. And then we get to 2004 retail fraud, second degree. And what you will notice after those string of retail frauds, which as this court is very aware of, is very indicative of an individual with a substance abuse problem, is that you'll notice from 2004 until 2018, what we have is a gap outside of a few driving while license suspended, which were likely suspended due to his substance abuse problem. Now, I think that period of time is important because it does show that the individual that Mr. Legans can be during that period of time. He was married. He was employed. In fact, he owned a business as a restaurant owner where he also cooked, but also importantly, he did a lot of self-reflection as to his faith, and in fact was engaged as a pastor during that period of time. Now, what we see is after 2018, Mr. Legans, my understanding is at that point in time, he went through a divorce. He then got involved with the wrong individuals and began using, again. And so while Mr. Berman indicates that Mr. Legans is a dealer, and yes, he is being sentenced for possession with intent to deliver. As this court is well aware, individuals often deal in small amounts in order to feed their habit. Now, that is what I believe Mr. Legans was doing based on multiple conversations with him, based upon, at this point in time, over 2 years of representation and discussions with Mr. Legans. What he's indicated to me is pretty much, Your Honor, he's too old at this point. He's too old to be doing this. He's too old to be using. He already has a plethora of health issues, diabetes, heart problems, just ankle problems, and the use of substances only increases that. So, Your Honor, the agreement is, in my view, what the agreement is. As the court was provided, Mr. Legans did reach out to CMH in terms of setting out a treatment plan for him. That recommendation was for him to engage in inpatient treatment. But what I also note, and you will note in the pre-sentence report, is that during his incarceration so far, he is engaged with CATS in order to work on his substance abuse. So it's not as though Mr. Legans has been sitting in the jail, being unproductive, not trying to engage in what his demons are, and his demons involve the use of illegal substances and legal substances, namely alcohol. So, Your Honor, I do want this court to be aware of, while we have this massive criminal history, what we also have is that gap of the individual that Mr. Legans can be when he is clean and sober and away from, in my view, certain influences. Now, in a, what I'm going to call magical Christmas land world, we would get Mr. Legans out of Ingham County into an inpatient facility like Bear River up north. But I do understand what the agreement is. I believe it's a fair agreement. But I wanted this court to be aware of the information and the context in terms of that criminal history.
Thank you. You are a zealous advocate, but what I see here is less than stellar despite the excuses he may have. Sir, what would you like me to know?
It's kind of hard to talk about. It's like I'm stuck between two hard rock in a stony place right now. I come from a large family. I come from 8 brothers and 4 sisters. And only thing left in my family now is 2 boys and 1 girl. All the rest of them passed on, and a whole lot of them passed on because I come from a family that used drugs a lot. That's how I got onto it. They introduced me as, like, at the 1975, my family, my brother and sister introduced me to drugs back then. And I caught a habit of doing that all the time. My mother, father, they deceased. My father was an alcoholic. My mother had some type of dealing with drugs. You know, my whole family was and they call it dysfunctional family. As I was 15 and 16 years old back in 75, I was just tagged along behind them, what they did. You know, I see now that it was a bad choice I made. Probably behind my brothers and sisters the way I did. But it seemed like everybody was doing that back then, you know, so I kind of tagged along behind them. In 83, I went to prison for retail fraud for I was still in to maintain a habit. 2004, no, let me go back to 1990, 91, 58 of 94, and 9/16 of 96. My kid's mother moved to Colorado with me. And I only had a girl then. As she came along, we had another boy, then we had another girl. They diagnosed her with cancer in 97. A few months after my kid was born, they diagnosed her with cancer. And I ended up, we went together, but we just kept our kids together the most we could. And she ended up where she was so bad with that cancer, they were giving her them patches on her chest. And she was getting a real bad drug habit. Her drug habit was so bad where she figured that she didn't want to be around her family no more. So she up and left me and the kids. I took care of the kids myself. I ended up having a drug habit myself, messing with her pain patches. And in 2004, Child Protective Agency came in and talked to me because the people next door to me had called Child Protective Agency on me. They came and talked to me and said, well, they didn't call on you because it was a bad thing about you. You feel you need some help because you're trying to take care of your kids by yourself while you got a drug addict. So we're trying to help you right now. So you get anybody in your family, get your kids to until you get yourself better. I gave my kids to my niece. She just deceased last year in May. She took care of my kids until I got myself better. I ended up going to Eaton County Jail. I got a year in county jail with 90 days suspended upon completion of rehab. And I did 5 years probation at the time. And I ended up getting my kids back in 2007. At the same time I got my kids back from the state from my niece, their mother died at the same time, about a couple weeks later in that month. And, I stayed my ground. I stayed clean until 2018. I met another young lady in our church. I ended up marrying her. And I woke up one day and just realized this wasn't the woman I married. You know, she's still money out the cash register, having affairs behind my back with other people from other churches. She's the first lady of our church, but she walked out of our church and went to somebody else's church. And I find out I knew the person came by my house to fight me in my own yard about my own wife. It was just there was so much where I just I did my best to hold on to it, but it was just so many problems going on where I know I was wrong in a lot of ways, but putting me in prison right now ain't gonna help that. The only thing that we just make the problem more worse than what it is. I went to prison 2019 with a problem, and when I came out, I still had that same problem. I need some help. I don't wanna live this way. I'm 97 years old, and I don't know how much more time I got left in this life, but I know I don't wanna live it this way. Getting high and doing things to get money to get high with. I'm tired. Yeah, to throw myself to the mercy of the court, just to give me some help.
Sir, it's not just this court, but many courts, since it looks like from the history I have since 1983, have tried to help you. And in fact, in 1985, there was even a prison escape. You have told me a very sad story. I believe that story. But at some point, you're not a kid anymore, you're a man, and you don't look to illegal drugs and alcohol to help you. And I understand that's how you were raised, but we do have this, 14-year gap where you were married, employed, crime-free, and learned your lesson, and then something bad happens and you went right back to drugs. And the problem, sir, is you didn't just go back to drugs, you didn't just harm yourself, you harmed others. Because when you give, share, or sell illegal drugs, you're addicting or killing other people. And you don't know how many people died at your hands, how many people you helped with their addiction, helped make it worse, or maybe somebody else start an addiction. It's all connected, sir.
Can I say something?
What?
This is the honest God truth. I've never been a drug dealer. I've been a drug user. I ain't never deal no drugs with nobody.
Well,
I
sir,
use.
I have a history here. Did you ever share your drugs?
Yeah, we
Okay,
share.
that's called dealing.
We share.
Okay, no difference. No difference. I'm unclear what you think the difference is. When you share it, if you can give it for free, you can get money for it, you could get some permission to sleep on someone's couch, whatever. You share it, you shared it, you dealt it. And now I have to deal you your just reward, which is prison. That was your agreement. That was not the initial agreement, but now I have one file turned into 4 files over the course of a couple of years. I am happy you finally want treatment, but you're gonna get it behind bars. So there's nothing I can do, it's your agreement. And sir, I asked about whether or not you broke the agreement because I think you ought to spend more time in prison, not less. And I'm very sorry for your health, but your drug addiction did not help your health. The only one that caused your demise was you. And this history is horrible. There's no real remorse for what you've done here. We have guns, we have property crimes, crimes against the Department of Corrections, against law enforcement, and a lot of drugs, sir. And there, in 2019, you were ordered to complete TRICAP and you absconded from treatment. So maybe at 67 years old, you want treatment now, but that's pending jail or prison, I should say. And you could have gone to treatment at any time on your own, but you didn't. So I hope this time you avail yourself of the treatment in prison. They've gotten a lot better, but I cannot have any sympathy for you at this point, especially since not only do we have delivery manufacturer, and we have heroin, cocaine, there's lots of things, alcohol that you've abused, but multiple counts of firearms. I mean, we have people dying every single day, and firearms addiction, drugs, selling or sharing drugs, it all goes together. This has to stop now, sir. And if I didn't accept the agreement, I would delay matters more, so I'm going to accept the agreement. So therefore, sir, you are remanded to the Michigan Department of Corrections for 24 months to 360 months with credit for 248 days served. You'll pay a crime victims assessment in the amount of $130 and a state cost in the amount of $68. Those will not become due until 2 years after your release, sir. You can return pop-outs and get that paid off during that time. You also, once you are released, or maybe you'll do it before, you need to clean up these civil infractions, because they can do a warrant, and you can walk out of prison only to go back in because you haven't paid those, so figure it out. Maybe since you're arrested, they'll withdraw the money you owe, maybe they'll give you a time extension, but you need to deal with that, sir. You need to be accountable on all fronts, you need to be crime-free, drug-free, alcohol-free, and not turn to drugs when you have a problem. There's nothing in a divorce decree that gives you the ability to have, get out of prison free card because you were so affected by the divorce, you somehow have permission to violate the law and use and sell drugs. So your excuses are simply excuses that fall very short, sir. I hope you use the tools you learned. I do have, and I looked at this treatment plan. It's an exceptional treatment plan. They did right by you. The only one not doing right by you is you. Avail yourself of treatment in prison. Follow a treatment plan. Ask for help. Stay clean and sober. I think I noted that you have a sister who might be like 97 years old. You got longevity in your family. You're lucky. You're blessed that way. So you're also, by using all these drugs, killing that gift that God gave your family. There were a lot of issues in your family, but you could have stepped outside the drugs at any of these times that you were before multiple judges on these 10 felonies, and there's much more because they were all plea deals. So my hands are tied. You will be provided mental health treatment and health treatment in regard to the multiple issues you have physically, and also in terms of your addiction issues. You will attend AA, NA, or CA and any treatment programs they have. How do you support yourself, sir? SSI, SSD, work? What?
Homes.
All right, so you'll participate in any kind of trade school and any programming they have for finding you a home, halfway house, whatever they do in terms of the continuing treatment, as well as perhaps applying for SSI. Have you ever worked?
Yeah.
What kind of work do you do?
Cook.
Okay, so you have the ability to get a job, so you'll also be part of some kind of work seeker program, both on parole as well as while you're incarcerated. They have different kinds of programs where you can learn to do applications and do other things. So I don't know what prison you'll be at, but you will avail yourself of those things you need. So once you walk out of prison, you are no longer homeless or without employment, sir. If this keeps up, you will die in a jumpsuit in prison. Would you like to die a free man or an imprisoned one? Well, that's the right answer. Let's figure out how to get there. You know how to make good choices. You're certainly articulate. You have a 7th grade education, but you talk like you got a college degree. So you learned a few things along the way, but let's use them for good instead of evil. Drugs are evil, sir. They kill people every single day. Guns kill people every single day. Stay away from all of that. Choose the right side. And you know what it is. Obviously, you said you were a pastor.
Yeah.
So I don't know what you're gonna say to God, but you certainly turned your back on him. He's still there. I understand he lives in jail and prison. People find him there all the time. Maybe you can do some good to your fellow inmates and your own rehabilitation, finding him in there and having a few heart-to-hearts. You have 42 days to appeal and to request appellate counsel. I just want to make it clear that he does get the credit for the 248. Anything else?
No, Your Honor, I've given to the court the nollie process for the other files that will be responsible. Thank you.
And Your Honor, for the record, I am providing him a notice of right to appellate review.
Sir, do you acknowledge receiving your appellate rights, your 42 days to appeal to request appellate counsel? Do you acknowledge that?
Yeah.
All right, Thank you. Court is signed and announced. If you wait a moment, counsel, make sure you get your copies.
Thank you.
Thank you. That's all for the record.
You know, there's a point where the court stops hearing mitigation and starts hearing justification. Judge Aquilina clearly felt this cross that line, especially given the history and the harm tied to his conduct. But I'm curious what you think about how this was handled, so take a moment and let me know down in the comments. And if you enjoyed this video, do me a solid, check out one of the two that are on your screen right now. Thank you so much for watching.